Right. I would say if you encounter any particular situation, you can definitely call us and have us talk through the specific, because these are all, every one of these is different. And it's going to depend on, I've seen cases where that type of reasonable accommodation request is found by HUD to be, yes, the township can deny that wasn't reasonable. And places where the township was required to make that accommodation, depending on, what was the zoning district, what was the particular ordinance, what was the particular animal. And that's the kind of thing that if you encounter a particular situation, you are required to make a reasonable accommodation request. When it is reasonable, it may or may not be reasonable depending on the circumstances. So, that's I definitely encourage you to, we can definitely talk through the particular situation, try to get some case law that would apply, try to get some answers from as.
Because they can give a letter from the doctor doesn't mean that it should be acceptable and they should be able to keep that animal.
Right. If it is not reasonable under one of these criterias, due to the type of animal, if it's not technologically possible to safely accommodate a pig in an apartment, then it's not a reasonable accommodation request. Yes.
To the same situation, does it depend on the strength of the doctor's letter?
It does depend on the strength of the doctor's letters. It does depend on the, yes, it does. It does. And that's what we've been trying to really do, some education with consumers and some information for them to give to their medical professionals, because we've seen a lot of letters where they say, I think somebody would benefit from this. And we've seen, we've been in HUD cases with representing complainants where HUD is looking for that letter to say that this is really necessary, and that influences the way they're going to view a complaint. And I should also say, at this point in talking about the animals, is that the state of Pennsylvania passed a law that took effect in December that does make it a misdemeanor to knowingly misrepresent a pet as an assistance animal. So this law doesn't change anything about consumers' rights when they do have when they have a legitimate assistance animal. It doesn't change anything about landlords. Nothing about this law contradicts anything about Fair Housing Act rights and responsibilities, but it does criminalize the knowingly false requests.
Misrepresentation of a service animal, it's up in the air because who's going to enforce it? Who do you call? Royal Township Police, but they could care less.
No, that's a good question, and I'm not up on who enforces that law.
The organization, the restaurant owners, and everything else.
Mm-hmm.
Who do you call to enforce it?
Right.
The
Right.
Service Animal Enforcement Bureau? Come on. If they pass this law, yes, but there's no way to enforce it.
Right.
You're not going to confront the customer and say, and you're not allowed to ask them for documentation either. You can ask them what the dog provides, but you can't ask them for documentation.
Right. And
the whole thing is so bizarre.
yeah, I mean,
Unreasonable.
ADA is not my level of expertise. I'm not well informed on what you.
Great, desire in an election year to pass you get this passed, but there's no enforcement provision.
Right.
Nobody cares. Who cares?
Well, I mean, I can I can help clarify any fair housing related request.
You're right. It was passed and it is law, but there's no enforcement provisions except for the local police who people, they're not going to, well, I'm not going to bother with that.
Right. Well, I can tell you from our perspective as taking a lot of calls for consumers that when we're able to inform consumers about that law, it does affect their, it does make them think twice about making a request that is not appropriate. When they think to call us first and we can tell them that there is a state law that prohibits misrepresentation, it has an effect on whether they're going to.
It came about more or less because as a restaurant and a business owner, you can buy vests, a service animal
Right,
vest
right.
on the internet, and
Right.
it's becoming, it's out of hand.
Right, yeah,
Every
yeah.
animal all of a sudden is a service animal.
Yep.
And when you go to pet it, it wants to bite your hand off. So you know it has no training whatsoever. And under the law, it doesn't need to be trained as a service animal.
Right. In housing.
Exactly.
Yeah. Yeah. I mean, it is a tricky. The assistance animal issue is tricky. I can tell you that HUD is we don't know when, and we don't know what it's going to look like. They are anticipating releasing some clarifying guidance on assistance animals specifically. We can wait for that.
But it only applies to HUD. Exactly.
Right. Well, it would apply to any fair housing situation, not necessarily public accommodations or.
Can you provide us with a copy of that law?
Yes. Yep. Yeah, Sarah. Would you? Okay, I was gonna say, would you mind if you could like make a list of follow-up questions? Okay, great. Okay, so this I always recommend this particular piece of guidance. It's a HUD DOJ joint memo on reasonable accommodations and modifications under the Fair Housing Act. It's got a lot of detailed information on this issue if you're in a situation where you deal with reasonable accommodation and modification requests. I cannot promise it answers every single question that comes up, but both of these are really good resources. They're probably a 16-page, Q&A format, and I would recommend those. And we will make sure that you get a copy of this presentation as well. So any of the resources that are mentioned, we'll make sure you get this. Anything else on reasonable accommodations modifications? Okay. Design and construction requirements. This is just, good information to know. So municipalities, I'm going to tell you, actually are not liable for violations of the design and construction requirements, even if an inaccessible dwelling has been gone through the approval process in the township. The township doesn't have liability. So one of these design and construction requirements apply to a kind of limited subset of new construction housing. It applies only to multifamily housing, only buildings that contain 4 or more dwelling units, ground floor if there's no elevator, all units if there is an elevator. And these are kind of more like basic visitability types of requirements than full accessibility. You can see these are both Lehigh Valley examples, actually. You have the parking that goes nowhere, that goes to the steps, the steps into the units. And there are 7 design and construction requirements. And again, this is really basic visitability. Somebody with a wheelchair basically needs to be able to get in from the parking area into the rental office, any type of common use area, amenities, mailboxes, pool, whatever, and needs to be able to enter the units that are covered. And then there's some requirements about the level of environmental controls, the passages through the unit, bathrooms, kitchens, and having reinforcements for the later addition of grab bars if necessary. So I like to have municipalities aware of these requirements, even though the municipality doesn't necessarily have liability for violations. We had a nearby complex where it was a very large apartment complex. It was 26 buildings that all but 4 had steps into the ground floor units. And when we looked into the inspection process that occurred related to the construction of these, we went to the township, asked for the reports on the inspections taking place. There were 26 boxes, 1 for each building, and all the binders lined up, the drainage, the electrical, all of the different inspection reports. Each box had a folder for accessibility, and when you opened it up, it was not filled out. And, that's the sort of situation where the township doesn't ultimately have liability for that, but some knowledge of the design and construction requirements should have been implemented. I mean, they had an accessibility inspection folder with a survey in the box, but that inspection hadn't ever taken place. And it was a circumstance where the liability was on the developer, but it would have been beneficial for everybody involved from for the township to have implemented some oversight in that situation. Just a little bit about, again, differences between the ADA and Fair Housing Act. A lot of builders are confused between the two as well, and sometimes believe that if the parts of their complex that are required to be ADA compliant that they've met all of their obligations regarding accessibility. And then just, this accessibility requirements could be a full week of training. I'm gonna just give you some resources. There's a HUD design manual that's, about that big with lots of specifics on the technical requirements. And there's a Fair Housing Accessibility First, which is kind of a resource center, a helpline. They can take questions about accessibility issues. They're about 10 or so, 8 to 10 building codes that are considered safe harbors under the Fair Housing Act, and you can find all of that information there.
You made reference to accessibility and you made reference to mailboxes.
Yes.
Just make a comment. We have a federal post office here in Whitehall
Mm-hmm.
that doesn't have curb cuts.
So that would be an ADA issue.
And
Yeah.
tell them to put curb cuts there.
They won't, they tell us to get off their property.
It's a double speed.
Hmm.
That's why they don't have license plates on their trucks. And there was an elderly woman that was getting killed on her way to the post office there. There's no crosswalk there.
So I would recommend the Mid-Atlantic ADA Center. They're located in Maryland, but Pennsylvania is one of the states that they serve for that type of question of how to deal with that.
They don't own that building, the feds don't own it.
Yeah, they do when they were doing work on it in the past.
I thought they
Disability Rights Pennsylvania is another, another.
I did call ADA, and they said that they could enforce it, but it seems like you have to go to that extent. And file a
Right.
complaint
Right.
to get them to comply with their federal law.
Yeah, that's.
All right, thank you.
I mean, that's unfortunate. Sometimes that's what it takes. All right, so I think it's a good time to take a little break before we tackle zoning. Sarah, do you want to say how much time everybody gets?
Do your business and come back.
Get started again. Okay, so I want to say that despite the grumbling, that you all are much more engaged than my last government training of people who actually chose to be there.
If you moved faster, we'd be more engaging.
I think I heard 4 hours was part of the requirement. But we've used up a good portion of that. Okay, zoning and land use. So, under the Fair Housing Act, the law explicitly includes as a dwelling vacant land where residential housing may be constructed or will be constructed. And then this is just a quote here from one of HUD's rules that an ordinance is a type of land use decision that may discriminate from the moment of enactment. So HUD is concerned not only with discriminatory land use decisions, but also with ordinances that may contain Fair Housing Act violations or impediments. So like any type of other housing-related transaction, like the rentals, sales, mortgage lending, the Fair Housing Act prohibits any type of zoning or land use decision or law that may affect people of a protected class more than other groups. This, again, falls under that category, that the catch-all of make otherwise unavailable or deny. And, I'll talk a little bit more about the zoning ordinance reviews that my organization has done over the past number of years and what we've seen in local zoning ordinances. But just generally, in Pennsylvania we have the dubious distinction of being the state that has the most fair housing legislation around zoning of any state. So it's a common issue in our area, and speaking to the problem of having a lot of this occurring, a lot of limitations being imposed on people in group home situations and other types of zoning decisions. I get the frustration of that being occurring frequently in neighboring communities, and then having residents misunderstand what your obligations as a township are. I mean, it's really regionally. I have a Google alert set up for group home Pennsylvania, and I get articles every day because it's such a big issue, and kind of a resurgent issue with the whole addiction recovery home, kind of, bringing this group home issue up more currently. So basically, these are some examples of land use laws or practices that may constitute violations of the Fair Housing Act. So any type of law or policy that is going to treat housing that may be occupied by protected classes less favorably than those occupied by other residents. And I'll go into some specific examples when I start talking about the individual protected classes. Denying either group homes or multifamily or affordable housing in response to residents' fears about the persons who are going to be occupying that housing. Requiring any types of more burdensome procedural steps, extra studies, delayed decision-making in considering housing that may be occupied by protected classes, and refusing to make reasonable accommodations for people with disabilities in land use and zoning. And, again, we'll talk more about all of these in detail. So, like other types of housing-related transactions, we also have the issue of, I'm two different slides here. Okay, sorry about that. So, again, we'll talk more about this in the sort of interchange between Fair Housing Act and free speech issues, that you're in kind of a unique position in hearing and being responsible to the concerns of constituents while also needing to be knowledgeable about what laws and regulations that the municipality is required to be compliant with. And so often in land use and zoning issues, we have decisions that are made because of acquiescing to the concerns or requests of the residents, which their concerns may contain an element of bias against members of protected classes or fears about housing occupied by protected classes and their character of their neighborhood or property values or whatever those fears are. And just to be aware that when the elected officials may not have particular bias, but by making decisions based on biased views that have been expressed by residents, that can trigger a Fair Housing Act issue. And then also a little bit differently, but we also see decisions that are motivated by an attempt to increase housing opportunities for one particular characteristic of people, having the unintended consequence of also being inferior treatment of another member of a protected class. So what we see on a municipal level often is policies that are enacted, for example, to make more housing opportunities for elderly people can, in the way they're implemented, decrease housing opportunities for families with children. So that's just one area to be aware of when considering Fair Housing Act and the issue of, is everybody being treated equally based on their protected class?
But people are aging. We're going to need more homes for elderly people.
Right.
There has to be some kind of leeway given there to the fact that you have to have more homes for elderly people because there's more.
Yes, and I will talk about, when we talk about families with children, about, again, there are ways to implement that in a way that is consistent with the Fair Housing Act. So similarly to what I talked about previously with discriminatory effects and the issue of disparate impact based on a protected class, that various land use decisions or laws or regulations can fall under that area of having a disproportionate effect on a protected class. Again, this is really fact specific because it's going to depend on the demographics of your particular area, both as related to protected class status and socioeconomic status. But in certain situations, some types of zoning regulations, things like really large minimum lot sizes or unit sizes that have a very high, make housing very expensive to develop and unaffordable to develop, can fall under that category of having a disparate impact. Also things like prohibiting multifamily or small units or subsidized housing. So again, I'm not going to go through another example, 3-part analysis of disparate impact, but with these types of policies and regulations, I think to have that in the back of your mind, is this going to affect a protected class more than everybody else? Does this have a non-discriminatory justification? And if so, is there a less discriminatory way of serving that need? Is a good, it's just a good analysis to keep in the back of your head when thinking about the effect of any policy. So as far as families with children and senior housing, so under the Housing for Older Persons, which is the same law that allows apartment complexes or condominiums or developments to designate themselves as housing for older persons, municipalities can also legally implement senior housing zoning districts. So there are ways to implement the goal of creating more senior housing in a way that is consistent with the Fair Housing Act, and this is one of those ways to do that. So if a local government chooses to do that, and there are locally a number of municipalities that do have housing for older persons districts, the zoning district does have to meet that housing for older persons definition of either one resident in each unit being over the age of 55 or 100% of units being over the age of 62. So it is important to know that if a local government chooses to do this, that they're responsible to implement some type of process to ensure that the district continues to meet that, those guidelines. What we've seen as problematic in this area of zoning excluding families with children is when you have, well, first of all, we have seen a handful of zoning ordinances that actually contain language that the purpose of the regulations that they're implementing is to limit the number of children and the impact in the school district. That's kind of an extreme example, but I have seen that in several zoning ordinances. What's much more common is, rather than designating an age-restricted district, is municipalities implementing different regulations for age-restricted versus unrestricted housing within the same district. And, I see a lot of zoning ordinances where it's like there'll be a table with either use or dimensional regulations for senior housing, and it'll be like either there's a density bonus for senior housing, or it'll be a whole different set of number of stories, amount of building coverage, unit sizes that make it more attractive for somebody to develop senior housing. Yes.
Okay, kind of what I get that you're saying is that, you know, if we're allowing housing, you know, 55 and over, that we have the obligation to make sure that that housing is 55 and over continually?
So if you have an apartment complex in your township that's 55 and older, like that provider has decided to build age-restricted housing, that's their responsibility to make sure that they continue to meet that definition. If you as a municipality decide to have an age-restricted zoning district, then it's your responsibility as the municipality to implement something to ensure that that district meets the housing for older persons definition. So individual complexes, individual developments that are age restricted are responsible themselves to make sure that they meet that designation. If you have a separate district, then
Ongoing obligation.
yes, yeah.
But if it's just a use within a district and other uses are permitted, that does not apply, is that correct?
Right. Yeah, and the issue that comes with it being a use is when residential housing that's restricted only to older persons has requirements that make that much more attractive to a developer, or is treated more favorably than housing that could be occupied by families with children. Does that make sense? That it becomes a problem when there are two different sets of requirements in the same zoning district, that housing for older people is treated much more favorably in a zoning ordinance. So that's like a terms and conditions issue. Does that make sense? Okay. And then we've also seen municipalities that have age-restricted zoning districts and have a definition of age-restricted that's not what's contained in the Housing for Older Persons Act. That, they have we've seen 45 years and older, we've seen retired people, other definitions that don't conform to that Housing for Older Persons definition. Okay, any more questions on this? Okay, group homes. So under the Fair Housing Act, group homes there's a pretty broad definition of what might constitute a group home. And usually we think of group homes as those that are operated or licensed under a particular program, like a particular state program or particular model. But I just want to kind of keep in mind that the Fair Housing Act has a pretty wide definition of group homes that is less specific of what many people think of with group homes. We've had situations where, for example, a family who a couple of families who have adult children with disabilities may go together, buy a house, and hire an aide so their adult children can live independently. And that wouldn't fall under a particular program that's operating group homes, but would be considered a group home for the purpose of the Fair Housing Act. So as far as what's going to be considered a group home under the Fair Housing Act, it may or may not provide supportive services. It may or may not be for-profit, non-profit, operated by a program, operated by a individual, may or may not include some supervision of residents or the degree of supervision of residents, and may include people who are in recovery from alcohol or drug abuse. So we talked about the Fair Housing Act definition of people with disabilities. Under the Fair Housing Act, recovery from addiction is considered a disability and is protected. Current use of illegal substances is not protected. So if you have individuals who are active drug abusers, they're not going to fall under this category of people with disabilities. So basically, the general rule here is that group homes for small numbers of residents that are housed in single-family homes or single-family units should generally be treated the same as other residential uses. And I got into.
How did that ever come about? First of all, it's very clear what single-family home means.
Right.
Exactly what it means, single-family home. But now they turn around and say generally group homes for small residents, even though they're not related in any way, shape, or form, are to be treated as single-family residents.
Right.
It makes no sense whatsoever.
Right.
You're taking the whole definition of single-family homes and twisting it to fit the needs of someone. They may not even have disabilities. They're just being treated as a single-family home as a group home.
Well, I mean, I think philosophically, and again, I'm going to say I'm the messenger. I can't speak to the the intention of the 1988 amendments to the Fair Housing Act. Philosophically, the nation had a move towards deinstitutionalizing people. We closed the giant state mental hospitals, and a philosophical movement towards not segregating people with disabilities was made. And this is part of a lot of different regulations go towards this intention.
Well, in order to fit that as a group home,
Mm-hmm.
must they have a disability?
Yes. Yes. So group homes is only people with disabilities. So it's not, not other types of congregate living situations that don't include people with disabilities. This is only, essentially, in a lot of ways, this operates similarly to the idea of a reasonable accommodation, that it's something that only applies. And we'll talk about definition of family, because it is, let's see, I'll skip ahead to definition of family. So there's a Supreme Court case that really affirms the right of a municipality to make limitations on the number of unrelated people who constitute a family. So it's okay, it's legal, it's acceptable for a municipality to decide that they want to put limits on number of unrelated people who constitute a family. That, a lot of places that are near colleges and universities do that because they don't want to have lots of student housing. There are lots of other reasons why municipalities want to encourage, related people to be a family, and to limit the number of unrelated people that can live together in a household. So that's fine. However, it's important to know that there are two different ways of addressing how the definition of family intersects with group homes. I think increasingly, and I think this is it's an easy way to address the issue of group homes, a lot of municipalities are choosing to address the group home use in their definition of family. So they'll have a definition of family that says, any number of related people up to whatever number of unrelated people, or people meeting the Fair Housing Act definition of persons with disabilities, living together and the functional equivalent of a family and sharing common areas, cooking, whatever. So some municipalities are choosing to define family in a way that includes these residential group home models. The other option is to be aware that as a municipality, that if you do have a more restrictive definition of a group home, of a family, you don't include the people with disabilities in that definition, that you're going to be required to make a reasonable accommodation when it's requested. So those are kind of the two ways to deal with group homes as it relates to the definition of family. But again, reasonable accommodations only applies to people with disabilities. And we get calls from people in other situations who don't have disabilities asking about making a reasonable accommodation, and that's something under the law that's only going to apply.
Would disability include age? For instance, a four-bedroom house with 4 widows in it?
It could, depending on how they, we've had a couple of, interestingly, we've had a couple of issues where we've had, although age under the state law isn't going to require a reasonable accommodation, even though it's a protected class. But, if people are experiencing age-related conditions that rise to that level, then, I would think that would be an area where it's gonna depend on the circumstance. There was a case that we read about just like somewhere in the western part of the state, and I just read the news article about how they had a zoning ordinance that allowed a certain number of men to live together in a home, but not a certain amount of women. And it was determined that if you had like a certain amount of clear Fair Housing Act violation, that it was like a brothel, that it was assumed to be, it was some really outdated ordinance that assumed if you had,
When I was in college, they were allowed to have the fraternities were allowed to live together, but these sororities were not.
this,
Under the state, there was something with the state, and they were considered a brothel.
this was something,
College, Pennsylvania.
I forget whether it was 5 or 6 women, like that. It was just some really obsolete law that was still on the books. So just some local examples of violations that we've seen in relationship to group homes. And again, Pennsylvania has a wealth of case law regarding Fair Housing Act and group homes. So these are pretty well litigated issues. One of them is spacing requirements and ordinances that require group homes to be spaced a certain distance from each other. We've seen all sorts of zoning ordinances that have additional burdens placed on group homes. Everything from like sprinkler systems to, planted, you can have a group home in a residential area, but you have to have like 8 feet of shrubberies screening it from view. Additional inspections, all kinds of additional, additional burdens put on group homes. I didn't put it on this list. I can't believe it's not on this list, but obviously, group homes not being permitted in residential districts is a really obvious one. Enforcing provisions of ordinances more strictly against group homes than against other types of residential requirements. There are some licensing and registration requirements that I've seen that are really falling into that area of inquiring about the nature and severity of people's disabilities, requirements that group homes submit a lot of information about the type of disabilities that are going to be accommodated at these group homes, and then the exclusion of addiction recovery homes.
Doesn't the state law kind of should it, I mean, do it to themselves? Because I know with the fire department, those facilities are required to provide notice to the fire department
Right.
of their existence.
So we get a lot of questions about, you know, and it's similar to the question that somebody asked previously about. The question was about housing vouchers. It was the question that you had about a program requirement that seems like it conflicts with the Fair Housing Act. And we've gotten a lot of questions about the programs that certain types of group homes are licensed under, containing some of these provisions. And it's just important to kind of make the distinction that program requirements for a certain program are sometimes going to have requirements that might not be legal for the township to impose. So some group home programs have their own spacing requirements because they're trying to avoid the segregation of people with disabilities all in one place. So there's some group home programs that say, group home operator, if you're going to operate under this program, you can't be within, 3,000 feet of another group home.
But actually, it's logical and it makes sense, like this whole notification of the fire department, because, there have been tragic occurrences where
Right.
these people are not capable of helping themselves
Right.
in a time of emergency, and so they need to be aware, and to, from the building code side of me says,
Right.
well, there should be higher levels of inspection for these
Mhm.
facilities to protect the residents, because these operators,
Right.
they don't
Right.
really
Right.
live there.
And we have had, we've had that particular question come up in, I've heard that question come up, and I've heard the advice given that it might be a better implementation of that type of policy to have that be a more universal type of question that you would ask of residents, and to have families or other residents of the township also have.
Reality of the occupants of
Right,
that structure.
right, right.
Because, when there's parents and children, they're typically, but these are, typically they're adults, and I'm talking about those with, disabilities,
Mhm.
significant disabilities. And again, there's been some tragic occurrences that
Right.
we read about it, where these people died.
Right.
Because they did not know how to act in an emergency, they did not know how to get out, there wasn't sufficient notification requirements.
Yes,
That's
yes.
a flaw
And
in my mind, in the law.
yeah, and we have, I think there's recently been a move amongst municipalities to implement their own licensing requirements. I've gotten questions about, from a couple municipalities where they're putting in place, understanding they can't restrict group homes, then trying to put in place licensing requirements that address some of those concerns. It's kind of a gray area. I don't know of any litigation that looks at whether there are fair housing issues related to that, but I have been able to get some of those reviewed by, national experts that really specialize in these issues. And so, if that's something that the municipality is considering at any point, that's something that we can talk about, trying to get somebody to review.
Inspections, and, you say licensing requirements, registration requirements, we don't typically require them to have licenses and registration any other different than any other landlord.
Right,
And
right.
Anytime a property is re-rented or sold.
Yes.
We require all of them to get inspected.
Yeah.
But it just kind of flies in the face of reason that these aren't just a little bit more belt and suspender, you know, because
Right. Right.
again, you're dealing with people that, and even the caregivers, depending on the caregiver's level of ability or, and some of the tragedy is we've seen caregivers assigned in group homes, you know, you have a 95-pound female that's
Mm-hmm.
assigned as a caregiver
Mm-hmm.
for a 300-pound male that,
Right.
you know, has
Right.
physical issues and.
Right. Yeah, I've seen some other municipalities kind of exploring the idea of a separate licensing procedure for group homes that may or may not be, may or may not. I mean, I've been able to.
I wish it would come down from the top.
Yeah,
Because it's
yeah,
logical.
yeah. I mean, I think that's probably an area where there will be some litigation, and we can kind of get a sense of what, what's going to be deemed acceptable and not acceptable in that sort of situation. But we have kind of a difficult situation in Pennsylvania because we have a different, some types of programs have to be licensed, some don't, and there's some program requirements that address some of these that aren't as consistent here as I think they may be in some other places. But again, when individual circumstances come up, I'm happy to talk and do the best thing. If I can't answer the question and I don't have a really solid answer to get to somebody who can. Okay, any other questions on group homes? I know this is it's another tricky area. So reasonable accommodations and in zoning and land use, again, similar to reasonable accommodations in any other type of housing transaction. It's the same kind of 4 factors about unreasonable administrative and financial burden, fundamentally altering the zoning ordinance, technologically possible and not causing harm or damage. The really, really easy example of this is somebody who needs a ramp to access their home, and the ramp, extends into the yard requirements, and they request a reasonable accommodation to build that ramp. Would be a really easy example of the types of reasonable accommodations requests that come up in a zoning context. And the definition of family issue, that if there is a more restrictive definition of family that doesn't specifically include group homes for people with disabilities, that a reasonable accommodation might apply in that situation. So this again gets to your question of the issue with that fair housing complaints happen only in response to complaints, and there are lots of municipalities in our region that have violations in this area. So a few years back, we reviewed all of the zoning ordinances in the suburban Philadelphia and Lehigh Valley region and found that almost half, very nearly half, did have either violations or things that didn't quite possibly reach the level of a clear, blatant violation, but were a fair housing impediment. And I've mentioned all of these before. Again, the restrictions on group homes, spacing requirements, or restrictions on where they could be located, or various additional burdens placed on group homes and the issue of different requirements for senior housing versus family housing. Just a few zoning case examples, again, since there's so many of them in Pennsylvania, that address some of these common ones. There was an Upper Southampton, which is in Bucks County, where a spacing requirement was found to violate the Fair Housing Act. They actually previously had a 3,000-foot spacing requirement, kind of got into trouble with that, decreased it to 1,000 feet, and that was still found to be a violation. The issue of reasonable accommodations in group homes, that this group home needed a reasonable accommodation to allow 8 individuals rather than 5, and were required to make that as a reasonable accommodation. Here's that issue of the setback requirements in needing to modify a home to, in this case, use as a group home, and that the city was required to make that reasonable accommodation. I always throw this last one in. I think this is kind of pushing the boundaries of the Fair Housing Act, but there is a case out there that actually required a township in New Jersey to locate a nursing home in a residential zone rather than an institutional zone. Okay, and once again, HUD has a DOJ HUD joint memo on this issue. This is actually a reformatting of some previous guidance that just is kind of in a more clear and readable format. It has that Q&A format on particularly zoning and land use, but a lot of focus on the group home issue that is that's available to answer a lot, although not all of the questions that you may have.
Can we go back 2 slides real quick? Move forward one. Okay, refusal to grant variance for nursing home. And my apologies for missing some of this, maybe you've explained this earlier. But there was a request to build a nursing home in a residential zone.
Right.
That wish was not granted as a
By the
reasonable accommodation.
Yes.
And the decision ultimately allowed the nursing home to be
Yes.
developed in a residential zone. So does that mean if I have a desire to put a nursing home in any of our municipal zoning districts, that they would be allowed to do that as a matter of course?
I don't think so. I think this case, again, I think this case is kind of an example of how broadly the Fair Housing Act has been interpreted in certain situations, and I really should read more up in the details of this case to be able to, speak more fully to this. I suspect that, there was something about the requirements of that particular district that made it, that made it found to be a reasonable accommodation request. Because a reasonable accommodation, remember, can't change the basic nature of, in a zoning context, can't change the basic nature of a zoning district. So my speculation is that the location of this was probably in a higher density district where it would have been an appropriate, where it wouldn't have been a huge stretch to have that located there. May have something to do with the kind of ratio of how medicalized something was. I mean, I often get the question with group homes with issues of, treatment centers and differentiating what's really a residential use that may contain supports with a medical use that may have a residential character tangentially to being primarily a medical facility.
Nuance here that we don't have identified.
Yeah. Yeah, I mean, this is a case, to be honest, if somebody had called me with that case, I would have been like, no way, you don't have a fair housing case here. And that it actually, I put this one in here kind of because it surprises me that it exists. Okay, anything else on zoning? Okay. All right, nuisance and crime-free housing ordinances. And this, I'll get into, there's some HUD guidance on this that is relatively recent. And nuisance ordinances are those types of ordinances that define some kind of conduct as being a nuisance when it occurs on residential properties. Usually they take the form of being like a certain number of calls to emergency services over a certain period. Some of them have a certain lifetime limit on emergency services calls. I've seen these range from like, 3 911 calls to 3 911 calls a month to what's going to be kind of flagging something as a nuisance property. And usually what happens with these ordinances is that the onus is on the landlord of a rental property to abate this nuisance situation. And usually they're required to evict the tenant, or else the landlord will receive fines if they allow this nuisance to continue to occur. And basically the concern with this type of ordinance, nuisance ordinances aren't really automatically considered to be a Fair Housing Act violation. But the issue with them is often they're pretty arbitrary and non-specific as far as not differentiating whether, for example, somebody's calling emergency services because they're the victim of a crime, because they may need medical assistance, whether a call is made by the resident or a third party or a neighbor. I mean, I think that it's pretty obvious to us that somebody who is an elderly or disabled resident calling for emergency services is a different situation than the neighbor has to call the police over and over and over because somebody's disruptive or something like that. So the Fair Housing Act concern with these types of ordinances is basically in differentiating when an ordinance like this is enacted in a way or implemented in a way that may affect somebody of a protected class, whether it's somebody who's a victim of domestic violence or somebody with a disability or some other protected class where they may be utilizing emergency services, but because of the way the nuisance ordinance is written, that they're going to fall under a category that probably wasn't the intention of the law. So really similarly is crime-free housing ordinances, the same sort of issue with being ambiguously written often, not differentiating whether the potentially criminal behavior is by the tenant or resident, by a guest, and whether there's the issue of somebody being convicted of a crime or simply being possibly a police call. So again, there's been some recent guidance on this that particularly addresses the issue of unintended discriminatory discriminatory effect of these laws in specifically the domestic violence issue, being a victim of another crime, or being somebody with a disability who needs those services. And the local example of this, probably a lot of people are aware of this case because it did make national news a few years back, is Norristown Borough in Montgomery County had a pretty, it didn't allow a generous number of emergency services call. There was a law that required landlords, when there had been a 911 call to a property 3 times, that the landlord faced a $1,000 day fine for that. And it was a particularly horrible case of a resident who had an ex-boyfriend who had been abusive, who returned several times to the property. She had the two 911 calls and had kind of a warning by the landlord. And the abuser returned, injured her very severely. She didn't call because she was afraid of being evicted, and the neighbors called 911, and she had been injured severely enough that she had to be airlifted to the hospital. And the landlord was in the position of either having to evict her or faced a fine of $1,000 a day. So, that was really found to be a law that was enacted in a way that made it a fair housing violation. Anything else on nuisance ordinances? Again, the guidance, the website for the guidance is there. Okay, this last piece on in the kind of municipality-specific fair housing issues is a little bit of a grab bag of other miscellaneous areas that local government is dealing with that has fair housing implications, mostly based on the types of complaints that we receive in our office and things that people complain about their municipalities regarding. So under the Fair Housing Act, any other type of municipal services, if there's a housing tie-in, need to be implemented in a way that's fair to everyone based on their protected class. Nationally, there have been really some extreme examples that I didn't put in here as specific examples because they're really go without saying. There was not so long ago a case in Ohio where a municipality was providing water service to the white side of town and not to the black side of town. So really kind of blatant examples of how municipal services affect people's access to housing and have been implemented in discriminatory ways. So we've gotten some calls about code enforcement and the issue of code enforcement being implemented or being enacted more strictly against some groups of people than others. Sometimes that has to do with renter-occupied versus owner-occupied housing, so kind of a disparate impact issue where renters are more likely to be protected classes in these municipalities, and they're the ones who are receiving the code violations. Some that, some complaints where a municipality is pursuing code issues on its own volition in some neighborhoods, but leaving the other neighborhoods to only look at things when there are complaints being received, and enforcing occupancy and health and safety ordinances against only some types of housing, sometimes only against group homes for people with disabilities. And go ahead.
Because I actually have a township that I'm working with on this.
Okay.
They're actually charging a fee every year,
Mm-hmm.
a yearly fee to register that
Mm-hmm.
housing,
Mm-hmm.
and then inspections every 2 years,
Okay.
whether there's been a changeover of tenant or not,
Okay.
which becomes quite a financial burden to
Right.
landlords, especially if you're trying to not raise your tenants' rents.
Right.
And keep them affordable for them. And it's not just when the units are, most of the townships are when the units turn over.
Mm-hmm.
An inspection for
Mhm.
the next tenant comes in, which seems very reasonable.
Mm-hmm.
But is there anything about that?
Yeah.
And
So
single-family homes, if you have,
if you live there for 30 years, you don't get an inspection for 30 years,
or
right?
if supposedly even if you're renting to a family member, they're not requiring those people to have inspections either.
Right, right. So I got this exact same question a couple weeks ago about, that issue. And I think it's going to depend on what the intention is behind that and whether that is affecting people based on their protected class more than other groups of people. We've definitely, so I live in Delaware County, where there's a lot of, we have a lot of municipalities where historically kind of anti-renter policies have been implemented that are very, sometimes really explicitly really about race and familial status. So, I think it's going to depend on the specifics of the town that you're talking about. I mean, in Delaware County, our Realtors Association has been really kind of heavily involved in looking at these kind of anti-renter ordinances in various municipalities.
I know there's a lot more properties in that township that are in, like my properties are all brand new that I
Mhm.
built. So,
Mm-hmm.
and I'm like, I can walk down the street and say all of those have electrical code violations.
Right,
Which is a fire
right.
hazard.
Right,
But you're gonna make me pay $50 for each townhouse and then
right,
have it inspected every 2 years and pay a fee for the inspection as well.
right.
Which is just increasing, and again, trying to keep rents down, it's very difficult sometimes.
Yeah,
Actually,
yeah.
a lot of the bigger cities do that, like Allentown has that too. They have a rental licensing program. They don't do like we do. We do every time a property is rented, sold, leased, we do an inspection.
Yeah, that's
But
pretty
Allentown
useless.
does like every 3 years, and you have a landlord license or a renter's license, and it's cyclical, but they freely admit they don't get to everything that they're
Mhm.
supposed to in that time frame. But that's how they do it. They don't do it based on change of ownership or
Well, and
change
the
of
interesting
occupancy.
thing with this township is that if I have a 4-unit apartment building, I pay $50. But because I have 3 half of twins, so one to our daughter,
Right.
I have to pay $150. I'm like, how
And
is that?
I think that sort of thing that the question was about, kind of having a rental unit inspection procedure that the capacity of the municipality is such that they don't actually get to everybody. And that's what I always talk about, whether it be housing providers or municipalities, is that's the kind of thing that may not be discriminatory but is really open to interpretation by residents as looking discriminatory. And I always really want to kind of warn providers or municipalities that something like that they're not really capable of implementing in a way that feels fairly to residents really opens them up to discrimination complaints, even if it's not.
Can I ask a question about, about the complaints?
Mm-hmm.
So, is it your recommendation, that, you know, just based on our personnel, we're complaint driven.
Mm-hmm.
However, if the code inspector is out there and notices there's
Mhm.
another violation here, there's another violation here,
Right.
where's it at?
I think it's important to have a policy and to abide by the policy. And if your policy is we respond only to complaints, but if a code inspector is responding to a complaint and notices other violations, that's I think it's important to articulate what the policy is and then document that you are following the policy that you have.
Because I've noticed other municipalities that have a position that they will not go on anything
Mm-hmm.
unless they have a complaint.
Right, right,
And, you know, I like that,
right,
but I don't know that that's really logical
right.
for the better, you know, health and safety and welfare of the community. But by
Yeah.
nature of, you know, where there's higher density housing, where there's, and let's face it, where the older neighborhoods are, the turnover is there, they are typically those census blocks that are, you know, the lower income. And when you go out there, there's more housing, so yeah, it does look like there are more complaints
Right.
being followed up on in that area. But there are more violations.
Yeah, and I think when we have consumers call us to complain about something that they're perceiving rightly or wrongly to be discrimination, what they're typically saying, they're typically calling us and saying, this is supposed to be the municipality's practice, and they're not following their own procedure. So it's perceived by that person as being discriminatory. So I always think really having a procedure, following the procedure, and documenting that you're following the procedure. Because whenever there are deviations in what the policy is when it gets opened up to, was that discrimination? And it really risks the appearance to residents that there's discrimination occurring, even if there isn't. And, moving on kind of along the same vein to use and occupancy and rental unit permitting procedures. So what we've been receiving increasing complainants about is these procedures when the forms and the paperwork requests information that could be used to discriminate. Sometimes we're receiving actual complaints that it is being used to discriminate. We've been getting complaints from housing authorities who talk about the municipalities requesting information about a subsidy, and then the allegation is that they're really delaying the inspection process, having repeated inspections of units when it's a tenant that has a housing subsidy, so that that tenant is risking running out of time to use their voucher. And we've also gotten complaints. These are typically complaints from landlords about the municipality, where they're concerned that the information being requested about the source of subsidies could be used to discriminate, or asks for information that can, again, have to do with the nature and severity of a disability. So, we've had landlords say that they've rented to people who are receiving rental assistance from a variety of sources. They were talking about refugee resettlement assistance, domestic violence programs, HIV/AIDS programs, and just to be cautious about, again, discrimination based on that type of information being asked by the municipality, but also the appearance of discrimination when that's being requested. Okay, so ordinances regarding undocumented immigrants, and these, there are a handful of municipalities that have passed these ordinances, kind of similar to the nuisance ordinances that penalize landlords, usually landlords and employers, for either renting to or hiring undocumented immigrants, usually implementing some kind of fine or other type of penalty against the landlords and the business owners. We've done some investigation into some of the places that have these types of laws, and it's, you know, the obvious fair housing concern is that it really encourages landlords to discriminate based on national origin, that they're much more likely to, you know, to treat people differently based on their national origin when this type of law exists. And the city of Hazleton had a law. It was another $1,000 a day fine for landlords who rented to undocumented immigrants, and just additionally declared English as the official language and barred city employees from translating documents to another language without approval. Just for the attorneys in the room, this actually wasn't a fair housing case. The theory was that the municipality was overreaching and exercising powers that weren't within their right to do so. And they were really dug in on this. There were several appeals, and they ended up with a really substantial payment in terms of reimbursing the plaintiff's attorney's fees in this case. Okay. So fair housing and free speech, and this, you know, I think this conflict is really where municipalities end up in a really, really, really difficult situation. That, you know, you're in a situation where you're responsible to hear the sometimes discriminatory viewpoints of residents, yet also required to comply with the Fair Housing Act in not, you know, not acting upon those viewpoints. So just, you know, a note on advertising and statements, that any kind of statement that's made by somebody who's required to comply with the Fair Housing Act in a housing context is going to be considered commercial speech, and therefore those statements can result in Fair Housing Act liability. And on the other hand, and I did, you know, got kind of interested in looking into some of the case law around this. There's a really interesting Fair Housing Act case, and there's an interesting free speech case that really, I think, inform this tension, that there's a fair housing or a free speech First Amendment case that really explicitly requires elected officials to hear discriminatory viewpoints that are expressed by constituents. It's an Ohio, I think, Cuyahoga County case that says as an elected official, elected officials are required to hear discriminatory viewpoints that are expressed by their constituents. And so as a local government, you can't suppress that kind of speech, but you're also need to, at the same time, make it clear to residents that you're required to comply with the Fair Housing Act and need to make decisions based on your responsibility to comply with the law. The fair housing case on this is another interesting one where it's actually a case in which a nonprofit developer who couldn't get a permit to build the affordable housing that they had proposed due to a lot of opposition being expressed by residents, pretty intense campaign of opposition. The permit was denied by the municipality, and they filed a complaint against not only the municipality, but the residents who had opposed the complaint. HUD took the complaint, investigated the residents, and then the HUD employees were sued for infringing on the residents' free speech. And it was found that, HUD was not permitted to pursue fair housing cases against residents of a municipality that were expressing opposition to housing based on the protected classes of people who would live there. So it's a really, I think in some ways there's a clear line between allowing residents to express their opinions, yet also following the Fair Housing Act, but obviously just on a personal and professional level puts local government staff and local government officials in a difficult situation with these types of decisions. So just, again reiterating that both the fair housing rights and the free speech rights are really, really important to keep in balance and to be aware of the local government responsibilities in both areas. So I have half an hour of time left. I am not going to get to all of these things in detail. I think I'm going to really try to, at this point, half an hour left. Should I just keep going? Okay. I'm going to fly through the recent HUD guidance and program rules. This is stuff that you can all look into later if it's of particular interest. Talk a little bit about affirmatively furthering fair housing, recent status of that, and then, save a few minutes for any additional questions. Also, what we do, what we can help you with in the future if it comes up. So these are just a couple of more recent guidance, again, grab bag of issues. The criminal records guidance basically addresses landlords or housing providers' rules about criminal records for prospective and current tenants as a disparate impact issue. Basically, talking about disparities in our justice system, leading to if you have blanket bans based on criminal history, that will have a disparate impact in a housing context. And it's a difficult rule to talk about because the first kind of cases addressing this issue are not decided yet. There are a number of cases in various stages of litigation that, you know, I'm eagerly waiting to see how they turn out to be able to just better advise people on how to comply. But basically what HUD is saying is that to say that for a housing provider to deny anybody with a criminal record, whether it be a conviction, whether it be just an arrest, whether it be for minor or major types of criminal activity, no matter how far long ago it occurred, is probably too overly broad and can be considered a Fair Housing Act violation because of having a disparate impact due to either race or disability. So HUD is encouraging in this guidance that they're saying blanket bans are too broad, are going to be considered Fair Housing Act violations, and that housing providers should employ some type of individual analysis as far as the nature and severity of criminal behavior with regards to amount of time that's passed since criminal behavior occurred, and you know, factors like whether there's any evidence of rehabilitation of somebody who has a criminal record. Again, this is really, really, really tricky because you know, the principle of the Fair Housing Act has always been reasonable accommodations aside, have across the board equally applied rules and regulations, and then there's some indication that housing providers are being recommended to look at things on a more individual basis. So this whole criminal record guidance and issue is kind of one where I think stay tuned to see how some of these cases turn out as far as what the gray area is and what's considered to be an appropriate use of criminal records in making housing, you know, making decisions on who can occupy housing. This also has an exemption that HUD says regardless of if a criminal record policy has a disparate impact on one of the protected classes, if there's a rule that they will not rent to somebody who's been convicted of illegal manufacture or distribution of a controlled substance, even if that does affect people differently based on their protected classes, they're going to be exempt from liability under the Fair Housing Act. So this whole, the criminal records rule is difficult. Again, could be another several hours long training. And I didn't include the website where this can be found, but if you just Google the exact words, the use of criminal records by providers of housing and real estate related transactions, you can find that rule or that guidance. Harassment, this was a rule that clarified when housing providers were going to be liable for Fair Housing Act violations in issues of harassment. A lot of the way that we talk about this is often in sexual harassment situations, but this would apply to harassment based on any of the protected classes, so racial harassment or harassment of somebody because of their disability. Basically clarifies the definition of the two types of harassment, one of them being quid pro quo, which is this, you know, you do this for me, I'll do that for you, usually in a housing context being a sexual harassment situation where a housing provider or maintenance person or whatever is requesting sexual favors in exchange for fixing stuff, rent, whatever. And hostile environment harassing is basically subjecting to people to harassment, which causes a hostile environment, deprives them of the right to enjoy their housing. So this rule answered a few questions about when certain things were going to be considered to be discriminatory. Clarified that an unwelcome request or demand in that quid pro quo situation is going to be considered illegal harassment, whether or not the person acquiesces to that demand. So somebody's in a situation where they feel like they can't lose their housing, acquiesces to that type of demand, even though they did, that's still considered to be illegal harassment. Hostile environment harassment doesn't require a change in any of the terms and conditions or benefits or privileges related to the housing transaction to be considered illegal. Neither psychological or physical harm must be demonstrated to prove that a hostile environment exists. It's really looking at